is Attorney Hachi, and welcome to Attorney Tips, the law in the market. Our topic for today's discussion is Article 13, the mitigating circumstances under the Revised Penal Code. So, here we go. For my students, just sit back, relax, and enjoy while we discuss the theories of the mitigating circumstances under the Revised Penal Code. So let's start, guys. Okay. Now, the first mitigating circumstance are those mentioned in the preceding chapter when all the requisites necessary to justify the act or to exempt from criminal liability in the respective cases are not attended. Anong ibig sabihin nito? Simulan natin. Pinakauna is yung incomplete na justifying circumstance, better known as incomplete self-defense or self-defense or defense of a relative or defense of a stranger. Okay? Now, take note that in self-defense, unlawful aggression must be present for Article 13 for it to be applicable as a mitigating circumstances. As a mitigating circumstance. Sorry. The other two elements is not necessary. If two requisites only are present, it is considered as a privileged mitigating circumstance. But if only unlawful aggression is present, then what? Only unlawful aggression is present. That's an ordinary mitigating circumstance only. Okay? Now, first, to have an incomplete self-defense, the offended party must be guilty of unlawful aggression. Without this, there can be no incomplete self-defense, defense of relative, or defense of stranger. Second, if only the element of unlawful aggression is present, the other requisites being absent, the offender shall be given only the benefit of an ordinary mitigating circumstance. Third, if aside from the element of unlawful aggression, another requisite, but not all, are present, the offender shall be given the benefit of a privileged mitigating circumstance. In such a case, the imposable penalty shall be reduced by 1 or 2 degrees, or depending upon how the court regards the importance of the requisites present or absent. Okay? Now, the second is the state of necessity or avoidance of greater evil or injury if any of the last two requisites is absent. There's only a ordinary mitigating circumstance. For example, so while driving a car, Juan sees Pedro carelessly crossing the street. Okay? Now, Juan swerves to avoid him, thus hitting a motorbike with 2 passengers, killing them instantly. This is common in accident cases. Take note that in this case, not all requisites to justify the act was present because the harm done to avoid injury is greater. It is considered as mitigating. So, that's it. Now, the performance of duty under paragraph 5 is the next mitigating circumstance. Example, Juan is supposed to arrest Pedro. This is previously discussed in the first cases. I think it's US versus Achong. He thus goes to Pedro's hideout, and when Juan sees a man asleep, thinking it was Pedro, Juan shot him. Juan maybe have acted in the performance of his duty as a police officer, but the crime was not necessary considered as was not a necessary consequence thereof, considered as mitigating. Now, there is a particular example present in this case, which is part of the defense of the accused. Do you remember the I don't care case? The involving police officer Nuesca? Okay. His defense, I believe, will be the performance of duty. However, since technically the one that the persons who died, the guy there, is considered as having committed a crime when he um shot a pillbox. I guess it's a pill. It's a homemade firecracker. So it is alarms and scandals. So ganun yon. However, in that case, there can be clearly, because of the video, there can be clearly no mitigating circumstance in that case. Because during the incident, Nuesca did not act in the performance of duty. He just simply lost his cool. Okay? Next, we proceed. Now, the exempting circumstance of minority, when take note that if you are a minor, if you are 15 years old and below, you are totally exempted. However, if 16 or 17 and you acted with discernment, you are liable for the crime charge. However, again, being 16 or 17 and or less than 18, you are considered as a minor still. And minority, mind you, is a mitigating circumstance. So next, causing injury by mere accident. So if in committing an accident, when you are involved in an accident, like in a car accident, and you're clearly, it's clearly an accident, but you are negligent. You did not do the proper car mechanic, car maintenance, and you have a faulty brake ever since, and you know that you have a faulty brake. When you are negligent, although it's an accident, it is considered as a mitigating because the penalty is lower than that provided for the intentional felony. Okay? Next is uncontrollable fear. When only one requisite is present, it's considered as mitigating. For example, under threat that their farm will be burned, Pedro and Juan took turns guarding it at night. However, when Pedro fired in the air when a person in shadows refused to reveal his identity, Juan was awakened and shot immediately the unidentified person. Turned out that the person was their neighbor who is looking for a pet. So, even though Juan may have acted under the influence of fear, but such fear is not entirely uncontrollable. So, it is considered as mitigating. Okay? Next. So, next is that the offender had no intention to commit so grave a wrong as that committed. It is praeter intentionem. Now, this is applicable only in crimes against persons. If the victim does not die, the absence of the intent to kill reduces the felony to mere physical injuries. It is not considered as mitigating, and mitigating only when the victim dies. Take note, praeter intentionem, the action to kill, there is no intent to kill here. But when the victim dies, the lack of intent to kill is considered as mitigating. But if the accused, the victim did not die, in the absence of intent to kill, it can only be serious physical, less serious physical, or slight physical injury. Okay? Next. Ito pa. Another example given. As part of fun making, Juan merely intended to burn Pedro's clothes. Pedro, in that case, Pedro received minor burns. Juan is charged with physical injuries. Had Pedro died, Juan would be entitled to the mitigating circumstances of praeterea Okay? However, this is not applicable in crimes, in felonies by negligence. Why? In felonies through negligence, the offender acts without intent. The intent is in intentional felony is replaced by negligence, imprudence, lack of foresight, or lack of skill in culpable felonies. There is no intent on the part of the offender which may be considered as diminished. So take note of that. Okay. Doble. Okay, next. Sufficient provocation. Okay. So, ito gumaganda ng discussion natin. The next mitigating circumstance is that the sufficient provocation or threat on the part of the offended party immediately preceded the act. So, take note, when there is sufficient provocation, this is also part of somehow in self-defense. It's a provocation, any unjust, take note, what does provocation mean? Any unjust or improper conduct or act of the offended party capable of exciting, inciting, or irritating anyone. Okay. Kabaliktaran ito pala guys ng self-defense. You are provoked. You are provoked to do an act. Let's say, example, sige, suntukin mo ako. Nung sinuntok ka, sufficient ba yung provocation? Nung sinuntok mo pala, sorry. Sufficient ba yung provocation? Take note that the provocation must be sufficient. Okay? Next. Immediate vindication of a grave offense. Ano ba itong ibig sabihin nito? The requisites here is that there must be a grave offense done to the one committing the felony. And two, that the felony is committed in vindication of such a grave offense. For example, Juan caught his wife and his friend in a compromising situation. The next day, Juan killed his friend, is still considered as immediate vindication of a grave offense. What is that grave offense? Adultery. That is a grave offense on the honor of Juan being the husband of the wife who cheated. Or when, for example, Juan saw his brother being killed by Pedro. Pedro was able to run. Juan did not what's this? Juan did not go to the barangay or report to the police station. The next day, he saw Pedro and immediately he killed Pedro. That is an immediate vindication of a grave offense. Okay? So, that's clear. Next. Passion or obfuscation. That of having acted upon an impulse so powerful as naturally to have produced passion or obfuscation. Ano yung requisites nito, guys? Passion or obfuscation refer to emotional feeling which produces excitement so powerful as to overcome reason and self-control. It must come from prior unjust or improper acts. the passion and obfuscation must emanate from legitimate sentiments. Okay guys, ito din. Example nito is passion and obfuscation. Nakita mo ulit si Juan, nakita mo ulit na niloloko ka ng asawa mo. Nakikipaglandian sa publiko. Doon sinaksak mo yung kalandian. That is passion and obfuscation. It produces an excitement so powerful as to overcome reason and self-control. It's an emotional feeling. So, the requisites nito is the offender acted on impulse powerful enough to produce passion or obfuscation, and that the act was committed not in the spirit of lawlessness or revenge, and that the act must come from lawful sentiment. Example nito is Juan saw Tomas hitting his son. Juan stabbed Tomas. Juan is entitled to mitigating circumstances of passion and obfuscation as his actuation arose from a natural instinct that impels a father to rush to the rescue of his son. Or, this in my first example, Juan killed the kalandian of his wife to protect his honor. Okay? Another source of passion or obfuscation is in the exercise of a right or a fulfillment of duty. Sorry. Yun nga pala. It's not a proper source of passion and obfuscation. Okay, next. Voluntary surrender. Or the offender had voluntarily surrendered himself to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Okay. Stop muna tayo dito, guys. Okay, we continue. Voluntary surrender is part of the mitigating circumstances. There are two mitigating circumstances here. First is voluntary surrender, and second is voluntary confession of guilt. Okay? Now, in this mitigating circumstance, the offender voluntarily surrenders to a person in authority or his agents, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Okay. Now, we discuss the specifics. Okay? Now, ano ba yung ibig sabihin nito? First, involuntary surrender, kailangan dito, what? The offender is not actually arrested. Offender surrendered to a person in authority or the latter's agent. And C, surrender was voluntary. Ibig sabihin, ano to? Not actually arrested. Hindi siya inaresto. Walang umaresto sa kanya. And voluntary, pumunta siya sa isang person in authority or the latter's agent. Now guys, dito sa voluntary surrender, sino tong person in authority na tinutukoy dito? Siyempre, ang person in authority, as explained before in the previous episodes, is that sila yung may control sa governance or someone who exercises authority over a certain community, like the mayor, the chief of police, or the simplest, the barangay chairman, or the latter's agent. Ibig sabihin, pag nag-surrender ka sa police, nag-surrender ka sa kagawad o nag-surrender ka sa counselor, agent yun ng mga person in authority. So, kung nag-surrender ka sa saan? Sa security guard, voluntary surrender ba yon? Hindi. So, kailangan magsusurrender ka sa person in authority mismo or sa agent niya. And surrender must be voluntary. Take note that surrender must be spontaneous. Anong ibig sabihin nito, guys? It shows his interest to surrender unconditionally to the authorities. Ibig sabihin, walang condition. Pag may condition, hindi yan voluntary surrender. Okay? So, ano pa, guys? The accused also must indicate a desire to own the responsibility in surrendering sa personal authority or his agent. Now, mind you guys, if the warrant is already served, surrender may be considered mitigating if warrant not served. Ibig sabihin, if the warrant is served sa kanya, saka pa lang siya sumurrender, may warrant na po. Syempre, hindi na po yan voluntary surrender. So, kailangan, if warrant is not served, surrender may be considered mitigating only if warrant is not served or returned unserved because accused can be located. Ibig sabihin, pag hindi pa siya inaaresto, voluntary surrender pa po yan. Okay? Kailangan po sa voluntary surrender, persona po yung magkusang loob na mag-surrender. At hindi po yung baril na ginamit or yung panaksak na ginamit. Also take note that a person in authority is one directly vested with jurisdiction, whether as an individual or as a member of some court, government, corporation, board, or commission. It includes barrio, captain, or chairman. Okay? So, yun. Clear na yun ang voluntary surrender. Now, ano yung voluntary confession of guilt or plea of guilty? So, ang requisites nito is clear. A, the offender spontaneously confessed his guilt. B, the confession of guilt was made in open court. And C, confession of guilt was made prior to the presentation of evidence for the prosecution. Now, in this confession of guilt, pwedeng mangyari to during arraignment or during pretrial. Now, before the presentation of the evidence of the prosecution, kailangan magkumpisa na po siya. Take note also that the confession must be attended with a competent counsel of his own choice. Otherwise, pwede niyang sabihin na coerced siya sa pagkukumpisan niya. Okay? Now, next. The physical defect. This is a mitigating circumstance na clear siya sa mga in this mitigating circumstance, physical defect. Sabi sa Revised Penal Code that the offender is deaf and dumb, blind, or otherwise suffering from physical defect which thus restricts his means of action, defense, or communication with his fellow beings. Anong ibig sabihin nito? The law says that the offender is deaf and dumb, meaning not only deaf but also dumb, or that he is blind, meaning in both eyes, but even if he is only deaf and not dumb, or dumb only but not deaf, or blind only in one eye, he is still entitled to a mitigating circumstance under this article as long as his physical defects restricts his means of action. defense communication with his fellow men. The restriction, however, must relate to the mode of committing a crime. Ibig sabihin, his physical defect, deaf, dumb, blind, prevents or restricts his means of action. Physical defect hindi yung sa utak physical defect. So, pag kaya niya pa rin gawin ang krimen kahit may physical defect siya, it does not restrict So, tingnan mo deaf and dumb, blind or otherwise suffering from physical defect. Deaf and dumb and blind. Ito otherwise suffering from some physical defect. Ito guys yung pilay. Putol yung kamay. Pero nakapatay pa rin gamit yung isang baril. Or nakasaksak pa rin. Take note. Mitigating ba siya? Hindi. Hindi siya mitigating kahit pilay siya. Take note. For example, in the crime of rape, dinahasa ng isang pilay ang isang bata. Kailangan ba siya maging pilay para gawin niya yung krimen? Hindi. Kailangan, ginagamit ba ang kanyang hearing sa paggawa ng krimen in the crime of rape? Hindi rin. So, hindi siya, it does not restrict him from committing the offense. So, therefore, that is not a mitigating circumstance. Okay? Next, illness. Such illness of the offender as would diminish the exercise of the willpower of the offender without depriving him of consciousness of his acts. Anong ibig sabihin nito? Ito guys, yung sakit, kasi illness. Minsan, sakit sa utak. Illness of the offender as would diminish the exercise of the willpower of the offender. What are the requisites? Ito. First, the illness of the offender must diminish the exercise of his willpower. And the illness should not deprive the offender of the consciousness of his acts. Kasi guys, if the illness deprives the offender of the consciousness of his acts, that is insanity. Okay? Now, pag diminish only, ano yun? Pag diminish only, that is a what? That is a mitigating circumstance. Now, example is feeble-mindedness of the accused, who in a fit of jealousy stabbed his wife, then carried her up to the house, laid her on the floor, and laid down beside her. Warrants the finding in his favor of the mitigating circumstance. Selos. Extreme selos. Pwede rin guys, mas madali yung passion and obfuscation. Okay? Any other circumstance or similar nature? Okay. Analogous circumstance. Ito yung mga analogous circumstances sa mitigating circumstance. Example, defendant who is 60 years old with failing eyesight is similar to a case of one over 70 years old. Outraged feeling of owner of animal taken for ransom is analogous to vindication of a grave offense. And impulse of a jealous feeling is similar to passion and obfuscation. Next is voluntary restitution of property, similar to voluntary surrender. And next is the extreme poverty, similar to incomplete justification based on state of necessity, and esprit de corps is similar to passion or obfuscation. So guys, this is this discussion. I hope you learned mitigating circumstances. Watch out for our next topic, aggravating circumstances. Thank you and God bless.